I would like to start by introducing our distinguished people at the high table. To my immediate right is the chairman of the occasion, the Right Honorable Professor Mike OQUAYE, the founder and distinguished scholar of the IEA Center for Constitutional Studies. Next to him is the speaker for the day, and that is Justice Emi Short, and the former commissioner, in fact, the premier and the former commissioner of Shraj. And our distinguished guest today, guest of honor, is our Honorable Okujeto Abakwa. I would also like to take the opportunity to recognize some important members in the guests, and in the person of Nana SKB Asante, who just arrived. At this time, I would like to invite the chairman, in the person of Right Honorable Mike OQUAYE, again the founder and the distinguished scholar of the IEA Center for Constitutional Review, to give us the chairman's remark.
Once more, recognize the presence of Dr. Asante of National Theme. He was the first to give a presentation on this matter we are discussing. And we are glad to have him here, not only here by way of his presence on this occasion, but be around to still be talking about matters related to constitutional review, because he will be seen as the father of the Constitution. And we are also glad to have our distinguished speaker for today, Dr. Short Justice, who had a very interesting, brilliant career and track that he followed. We have Honorable Okujeto here with us, who's here with us today, also as a special guest for the occasion. The IEA embraces all others, and that has been the kingpin objective of the institute that I have been associated with for several years. And we are also glad that you are here. The unexamined life is not worth living. No. We appreciate, and in fact, when Justice Bobby comes, he will give us a lot about some of the genesis issues related to the Constitution, the climate in which it was written at all, and how the CDR, for example, had 20 representatives, as against the Ghana Bar Association, we had one representative. And so there were a lot of issues. So we cannot just take this without examination from time to time. Consider, for example, that under our previous arrangements concerning the Council of State, a retired president was automatically a member, and how this was removed from the final edition because the president, the presiding chairman of the PNDC did not want that.
It is quite intimidating for me to take upon myself this particular topic in light of the fact that we have here someone who's been described as the father of the Constitution, but let's maybe aside him, and the chairman himself, who has written copiously on the subject. But I'm making this presentation as a citizen, not a spectator. I'm invoking my right as a citizen to express my views on the matter. The recent dogma has been Sika and Pedidi from the president. I think that my presentation might make some diddy when I'm finished. So let me go right ahead and first of all, I must make it clear that the topic is excessive powers of the presidents under the 1992 Constitution. I don't want any mischievous reporter to go and say that Emre Shaw spoke about the excessive powers of President Nana Akufo-Addo. This is not it. We are looking at the powers of the president under the 1992 Constitution, which I consider to be excessive. Now, in the last 3 decades, we adopted a liberal democratic system that ushered in regular competitive multi-party elections, peaceful transfer of power, constitutionally guaranteed freedom of speech and of expression, respect for human rights, independent judiciary, and countervailing institutions of accountability. The new dawn of democracy provided fresh impetus for entrenching participatory, accountable, and inclusive governance, political stability, and general expectation of material development for the majority of the people. Since 1992, Ghana has managed 8 successive multi-party elections that has led to a multiple transfer of power between the National Democratic Council, NDC, and the New Patriotic Party, NPP, administrations. Generally, the electoral processes have been managed in a free, fair, transparent, and peaceful manner. This is corroborated by local and international election observers. Unfortunately, there were 8 deaths during the 2020 national elections. However, and I must say these are positive strides in our democratic governance. So it's important to mention, these developments. However, the mammoth powers granted to presidents under the 1992 Constitution make them powerful and influential in all spheres of the political, economic, and social life of the country. The president retains the power to appoint the chairperson and 2 deputies of the Commission on Human Rights and Administrative Justice, the chairperson, 2 deputy chairpersons, 4 other members of the Electoral Commission, chairman, 2 deputies, and 4 other members of the National Commission for Civic Education, the District Assembly's Common Fund Administrator, heads of security agencies, including the Inspector General of Police, the Auditor General, head of Audit Service, Governor of the Bank of Ghana, the chair and members of the National Development Planning Commission, the chairman and other members of 1, the Public Service Commission, the Lands Commission, the governing bodies of public corporations, the government statistician, the Chief Justice and other justices of the Superior Courts, chief executives and board members of public enterprises, The chairperson, two deputy chairpersons, and 4 other members of the Commission for Civic Education, Metropolitan, Municipal and District Chief Executives, that is MNDCs, heads of the state investigative and prosecutorial agencies, 11 members of the Council of State, and there are other powers which I'm not going into because I'm just focusing on the powers of appointment. But the executive has control of a lot of other areas, even our natural resources, which can be considered on a normal occasion. As a result, the President exercises some forms of control within the executive and beyond in order to get his wishes done or undo anything that is not favorable to him. Presidential appointments are generally viewed as a courtesy to which appointees must reciprocate with favorable disposition towards the appointing authority. These practices are a recipe for patronage and cronyism and severely constrain the development of effective checks and balances and governmental accountability. Moreover, the unrestrained appointment powers of the President and weak oversight by the legislature often leads to large size of government that burdens the ordinary taxpayer. For instance, the number of ministerial appointments increased by 38 within 1 year under 2 different administrations, 72 under Mahama's administration, and 110 under Akufo-Addo's government by 2017. Further, the President's extensive powers of appointment and influence in all spheres of the state create a zero-sum electoral politics or a winner-takes-all politics, which makes it difficult for opposition and civil society to survive without the goodwill of the President. Again, ruling party officials and foot soldiers are given special privileges in public employment opportunities and implementation of government's special initiatives. Therefore, winner takes all undermine accountability and quality governance outcomes. More seriously, the winner takes all creates acrimonious relationship between the ruling and opposition parties who, due to the severity of the deprivations, quickly begins to frame their political actions around how to win the next election. The President's consent is also sought on positions he does not directly appoint, such as the appointment of board members or state-owned media. In addition, the President plays a crucial role in determining the end of service benefits and additional perks for most of the appointees, including Article 71 holders and even members of Parliament. The above appointments are done either in consultation with the Council of State or with the advice of the Council of State, and in some cases, additionally, with approval of Parliament. Of course, when we talk about consultation with the Council of State, nobody really knows how that process plays out. Because in the first place, the President appoints a majority of the members of the Council of State, and also the proceedings of the Council of State are not known to the public, they are not transparent, and so it's a process that we find a little bit awkward. Of course, the issue of the Council of State is a matter for another day for discussion. It has been estimated that the President has the power to appoint no less than 5,000 persons into the public service. Now this is serious. And so it's not difficult to understand the acrimony, the division between ruling party and opposition. Now, there are many who would say that, I'm glad that the majority leader is here, and I'm glad that Mr. Obakwa is here. And it will be interesting to hear their views when I'm through about this whole issue about the excessive powers of the President, whether they subscribe to it, whether I would see something in the manifesto of the political parties about a desire to curtail these powers, or whether, as some have argued, that opposition parties are only waiting in the wings to come and exercise these extensive powers, and also, as somebody put it, to milk the cow. As a result, it is difficult to build inter-party consensus on planning and implementation of key national development issues, and even harder for one party to continue the development projects started by the previous regime. This is a very serious matter, the inability of succeeding governments to continue the project of the previous governments. I have encountered a few of these instances where long stretches of road have been abandoned because the contractor who was working on it, the contract was given to him by the previous government, and so he is not able to continue because the incoming government is not willing to pay him. And so, in fact, there are moves to give the contract to somebody else who is more sympathetic to the current government. I mean, it is the people who suffer as a result of these intricacies of our politics, which I fail to understand. Now, Article 78 of the 1992 Constitution of Ghana provides that the President shall appoint the majority of members from among members of Parliament. Specifically, it states that Ministers for State shall be appointed by the President with the prior approval of Parliament from among members of Parliament or persons qualified to be elected as members of Parliament, except that the majority of Ministers of State shall be appointed from among members of Parliament. Conventionally, the number of ministers under the Fourth Republic has ranged from 70 to 110. I believe it has been reduced by the NPP recently. Generally, a minimum of 40 persons serve concurrently in the executive and in the legislature. Odipro, a parliamentary watchdog CSO, reported in 2017 that 71 out of the 110 ministers appointed by President Akufo-Addo in his first term were MPs, constituting about 25% of Parliament's entire membership. Since there is no cap on the number of ministers that the president can appoint, more than 50% of the appointees must come from among MPs. Again, as a matter of convention, the president appoints a number of non-minister MPs in the ruling party to serve as chairs and members of public boards. First, these practices over the years have undermined Parliament's ability to play an effective oversight over the executive. MPs who serve concurrently as ministers or appointees on public boards are reluctant to be critical of the policies and programs emanating from the executive for the fear of losing their ministerial positions. Again, the possibility for legislators to become ministers has conditioned non-minister MPs to act favorably towards the executive in order to attract the eye of the president for ministerial positions. In effect, it takes one to be an opposition MP, like the gentleman sitting next to me, in order to be critical of the government of the day. Appointing MPs to serve on boards and as chairs of state enterprises and corporations does not only weaken Parliament's oversight responsibilities, but also raises issues about conflict of interest, since MPs are mandated to play oversight roles of public entities. Can you imagine the quality of oversight by an MP who serves concurrently on the Finance Committee of Parliament and on the board of GCB Bank? In view of this, some international agreements have passed through Parliament without any critical debate or the needed scrutiny. Moreover, ministerial nominees almost always pass through parliamentary vetting without any serious challenge. And Parliament's lack of strong commitment in challenging the size of government defies their core mandate as protector of the public purse. Second, the temptation for MP ministers to prioritize ministerial over their legislative functions have dealt a blow to the legislature with respect to passage of laws, forming quorum to transact parliamentary business, etc. This was aptly described in a BBC Pidgin News as, quote, 85 Kubolo MPs, the slow Ghana Parliament with them absenteeism. I hope you all know what Kubolo is. Odikro reported in 2017 that MP ministers and MP deputy ministers were absent in 65% and 35% of parliamentary sittings, respectively. Also, ruling party MPs recorded an absenteeism rate of 72%, whereas the opposition party MPs recorded 28%. Speaker after speaker have lamented the absence of ministerial MPs in the House to deal with parliamentary business. These percentages are explained by the numerous engagements of ruling party MPs by the executive. Absenteeism deprives Parliament of a quorum to transact parliamentary business, that is 1/3 of MPs, and a quorum for decision-making, half of MPs. Notwithstanding, it must be recognized that the changing composition in Parliament has shown some level of parliamentary accountability, though not as strong as majority of Ghanaians would have expected from the legislature. Again, the introduction of Private Members' Bill under the 8th Parliament of Ghana is a great initiative that will decentralize the lawmaking powers within the state and allow Parliament, civil society, and the private sector to directly influence the lawmaking process. Mama Dr. S.K.B. Asante, who we are privileged to have with us today, who was chairman of the committee of experts appointed by the PNDC to draft a consultation, has lamented the creation by the 1992 Constitution of a, quote, monarchical executive. In his J.B. Dankwa Memorial Lectures on Reflections on the Constitution, Law and Development, he stated that initially he suggested that the presidential powers under the Constitution are on the whole not excessive. However, and I quote here, on further reflection and having regard to empirical evidence on the exercise of this enormous executive apparatus in our governance system, I am prepared to recant my views and concede that the powers wielded by the monarchical executive are indeed excessive. He further commented that executive or imperial presidency has given birth to the culture of winner takes all, which has a pernicious, divisive, polarizing, and retrogressive feature of our system of governance. This is why, he says, every general election is a source of great consternation and a potential source of conflict. During this moving towards the election, some of our churches have to go to the mountain hill to fast and pray to make sure that no disaster occurs. It happens every time we approach an election. Professor Jampo, who was until recently an integral part of the IEA, also have this to say on the issue. The exercise of extensive appointment powers of the president to the benefit of only some party apparatchiks and foot soldiers does not only promote WTA politics, it deepens clientelism and also undermines meritocracy by placing, quote, square pegs in round holes in the public service. Lee Kuan Yew, one of my favorite individuals who I admire for what he has done for Singapore, and if you read his book From Third World to First World, it should be a textbook for everybody in public service. He had this to say on meritocracy. I make no apologies for collecting the best talented team I could get in addressing the audience comprising of a cross-section of the people of Singapore. He said, without them, none of you will be enjoying life today in Singapore. I believe completely in the meritocratic system. I am not interested in who your father or mother is, unquote, the other statement which I didn't include. So in other words, I am hoping, although I might be too naive, that our political parties will in the not too distant future adopt the policy of meritocracy in making appointments to public service positions. Now, I want to have a look at the IEA Advisory Committee on the Winner-Takes-All system. This was a committee set up by the IEA in 2014 under the headship of Archbishop Charles Pamapakala, and I was also a member of that committee. and we undertook a nationwide public consultation process on this issue, and we made recommendations for reform. And I'll be presenting those recommendations and wait to hear what all of you have to say about them. But the team made the following recommendations. While appointment to constitutional bodies should remain under the President, recommendations for these appointments should emanate from certain clearly designated bodies that have the capacity to identify suitable persons using clearly predetermined criteria. A duly constituted body comprising professional bodies or institutions shall recommend suitable individuals of at least 5 from among whom the President shall make a nomination to Parliament. I'll be showing the composition of the various committees. But this is part of the proposal to ensure that we get the best brains for public positions, that we adopt a meritocratic policy rather than the policy that we adopt presently of the ruling parties giving positions only to party loyalists and party sponsors. As part of the recommendation, parliamentary vetting and approval of the President's nominee shall be by 2/3 majority of all members of Parliament. It is recommended that a strong tenure track and technocratic civil service be established. This should be an efficient body that can manage the affairs of the country in the absence of an elected government or coalition. Appointments of CEOs of public corporations and institutions and other analogous positions should be transparent, competitive, well advertised, inclusive, bipartisan, and based on competence. Nominations should emanate from the State Enterprises Commission, Public Services Commission, and appropriate recommendations made to the President for appointment. With regard to the legislation, some of the concerns which were expressed was the efficiency and effectiveness of Parliament is weakened by the current practice of appointing members of Parliament as ministers. And inadequate provisions in the Constitution should be made for parliamentary control over fiscal management of the economy. All ministers must be appointed from outside Parliament. Any member of Parliament appointed minister must resign his or her seat and a by-election held within 21 days to replace him or her. Article 108 of the Constitution, which deals with the legislative role of Parliament, should be reviewed to strengthen Parliament's primary role of lawmaking. The executive must be accountable to Parliament through a vote of censure. This must be binding and not dependent on the President's discretion. Presently, it depends on the President's discretion, and we recently heard that there is going to be a vote of censure on the Minister for Finance. And but if you look at the law, it says that if the vote is presented to the President, he may terminate the appointment of the minister. But we are recommending that it should be binding on the President, and the MP or minister should go. This proposal, if implemented, will mitigate the negative manifestation of the winner-takes-all system. It will promote inclusive governance and national development. They would facilitate the establishment of strong governance institutions. They would build consensus among governance stakeholders, government, political parties, civil society, and generate public confidence and public legitimacy in the institutions of state. Checks and balances between the three arms of government necessary for good governance will be enhanced. Now, I want to present the various committees which we suggested should be set up to identify persons who will be presented to the president for appointment, at least 5 persons. And in this regard, the positions would be advertised. Civil society should be able to submit names to the committee, of course with a person's consent. And there will be an interview by the committee, and the committee would then submit 5 names to the president, and the president would appoint from these names. Now for the Electoral Commission, a representative of the following: political parties with representation in Parliament, Judiciary, Ghana Bar Association, National House of Chiefs, TUC, civil in the areas of governance and democracy, Vice Chancellors of Public Universities, Christian Council and Catholic Bishops' Conference, Muslim Council and Ahmadiyya Mission. For the Commission on Human Rights and Administrative Justice, a representative of the following: the Judiciary, Ghana Bar Association, civil society organizations working in the area of transparency and accountability, civil society organizations working in the area of human rights, Ghana Police Service, Ghana Journalists Association, Ghana Medical Association, Trades Union Congress, Christian Council and Catholic Bishops' Conference, and the Muslim Council. The committee in charge of making recommendations to the President for appointment of an Inspector General of Police would consist of a representative of political parties with representation in Parliament, security agencies, apart from the Police Service, Ghana Journalists Association, Ghana Bar Association, Trades Union Congress, civil society organizations working in the area of governance, and human rights civil society organizations. For the Chief Justice and Justice of the Supreme Court, a representative of the following: Judicial Council, Ghana Bar Association, National House of Chiefs, Trade Union Congress, Christian Council, Catholic Bishops' Conference, and Ghana Pentecostal and Charismatic Council, Muslim Council and Ahmadiyya Mission. For the Governor of the Bank of Ghana, a representative of the following: Ministry of Finance, Ghana Institute of Planners, Institute of Chartered Accountants, Trade Union Congress, Chartered Institute of Bankers, Association of Vice Chancellors, former governors of the Bank of Ghana. For the Auditor General, the committee would compose of a representative of the Institute of Chartered Accountants, Trade Union Congress, Chartered Institute of Bankers, Public Services Commission, representative from the Ghana Bar Association, and Ghana Police Service. The National Commission for Civic Education, a representative from the following: Ghana Journalists Association, Ghana Medical Association, Trades Union Congress, political parties with representation in Parliament, Institute of Adult Education, CSOs in governance and advocacy, women's groups, National Union of Ghana Students, and the Economic and Organized Crime Office, a representative from the following: Trades Union Congress, Chartered Institute of Bankers, Ghana Police Service, Ghana Bar Association, Ghana Journalists Association, and Ghana Institute of Engineers. So, ladies and gentlemen, this is a recommendation which we actually forwarded to President Mahama when he was in office, but we never got a response from him. And as I said earlier, the whole idea of this kind of method of appointing people into public service is to ensure that we adopt the principle of meritocracy. We get people from institutions that can identify people who are qualified to occupy the stated position. And you do not take the power from the president. He has to appoint, but he would appoint from a carefully compiled list after interviews and so on. Now, as I said earlier, this may seem naive to a layperson like me, but I hope that the politicians will give serious consideration to these recommendations in order to put away this winner-takes-all system, which hasn't helped our country in any way, and also to ensure that we get the best people for the positions in public office. And it may be that this comes at a good time when our economy is in distress. Thank you very much for your attention.
The other different side of the parliament, we would proceed by allowing them to discuss, to be discussant of today's deliberations, and I will first invite Honorable Osechi Mensah Bonsu to give his thoughts about the presentation, and that will be followed by Honorable OQUAYE Ablakwa.
Mr. Chairman, the key presenter, Dr. Short, let me apologize for being late after Parliament sat and adjourned. I needed to have a meeting with my caucus because, admittedly, these are not normal times. And I know the Honorable OQUAYE and associates are fanning the embers, so I must always be on the lookout. That's in a lighter vein. Mr. Chairman, I think, Professor Chairman, I think even though I came in late, I caught the tail end of the presentation of Justice in the short. I must say ordinarily that I have nothing useful to add because I just opposed it with my own presentation last week. I think that we are on the same page. So I agree with the presentation that you have made. The other day, I provided a bird's eye view into all the areas. I attempted at least to do that. You have narrowed your presentation, and as I guess it's been indicated to you, to focus on the excessive powers of the president. I agree. The other day, I agreed with the position of Nana Dr. S.K. Asante that we have created a constitutional monarch for ourselves, and we need to confront the reality. And I think that we should be engaging in a holistic review of our constitution. I don't want a situation where people begin to talk about tinkering with the constitution, and as I hear some people say that, oh, let's implement the Constitutional Review Commission's recommendations. I agree that that indeed should constitute a major source of reference for us. But we must all admit that what they did is unfortunately inadequate given the circumstances that we find ourselves in. But it cannot also be an exercise in futility what they have done. My little point of departure, though, has to do with the emphasis that when you appoint ministers from Parliament, it may amount to a conflict of interest serving as ministers and also as legislators. I share a different opinion because we have the Westminster system where all ministers are appointed from Parliament and they do a good job. I think the reason why our own is not working well, we must admit, the US is the flagship of presidential systems. Ministers are appointed from outside Parliament. The ministers add value to governance because all of them who are appointed to various positions are experts and they add value to wherever they serve. In the Westminster system, the established Westminster system, for a person to be appointed a minister, that is, members of Parliament to be appointed ministers, they would have served in particular committees, perhaps risen to become shadow ministers. And there's nothing relating to that sector that person would not know. So if a person is appointed a minister from Parliament, he knows his bearings. And there's nothing that we can hide from him. Indeed, in France, for instance, the Committee on Finance is chaired not by a member of the ruling party, but a member from the opposition party, just like the Public Accounts Committee. When I asked, they said the Finance Committee is the fulcrum of governance, and nothing should be hidden away from the minority, that's the opposition. So members of Parliament who become ministers of state when their party wins are well enamored. Unfortunately, in our situation, we're having challenges because here we have presidents and all presidents who come, they appoint members of Parliament as ministers, deputy ministers. They are not experts in the fields where they are appointed to, first timers, and they have no knowledge of the sector that they are being appointed to the extent that at the appointments committee, when fundamental, rudimentary questions are asked them, they are not able to respond. And they tell you that, oh, please, I'm not there yet, you approve of me, let me go there, I will learn. Learn what? The Constitution provides that a minister of state should assist the president in running the state efficiently. And if you're a cabinet minister, you should be assisting the president to evolve policies in your sector. And the person is telling you that, let me go, I will learn. What assistance is he going to provide the president? We are falling foul because of our own ineptitude. Ineptitude on the part of Parliament, and maybe, as you said, this is because of maybe the president also has to satisfy his base. So all manner of people are appointed. So I think it's something that we should be looking at. My preference, if you ask me, is the Westminster system and not the presidential system. We are talking about the investiture of supreme power in the president. It's not so in the Westminster system. Fancy the situation we are in, and I'm just citing this as an instance. Maybe it should be Sometimes, as somebody said, I'm not afraid, but I feel small. Look, where we are, if it had been the Westminster system, my colleagues are raising issues about maybe the censure on the Minister of Parliament, Minister for Finance. Even the Westminster system, Parliament will take the issue, and the next day is not there. I'm not in any way justifying what you are doing. I have my own reason, but I'm saying that I'm not here justifying it. But I'm just saying that if this matter were to be in a Westminster system, the logical conclusion would have been reached. And the majority leader in the Westminster system is the Prime Minister. The majority leader just tends his or her own constituency. Even in these days of excessive monetization, look at how much the Member of Parliament will be spending in his own backyard. Compare that to what the President spends. No president would dip his hand into the national to reward people who might have supported him. But that is where contracts, when they are awarded, corners are cut. We all do know. And we saw the seeds of corruption in our own system. Look, from the selection of parliamentary candidates, what happens in our backyards? What happens in our backyards? We all do know, and yet we pretend that people are only being given drinks and cola. Kujetu and I know that it's not drinks and cola, it's something else. We saw the seeds of corruption there in the way we even select our parliamentary candidates, right up to the selection of presidential candidates. And we pretend everything is right with us. We can't fight corruption to the extent that the system we are operating continues. That is the bottom line. And the political parties must also be engaged. In any established system, members of parliament are assessed by their peers in parliament. They perform well, there is nothing untoward in their backyards, and to that extent, they are continued by the political parties. Here, every 4 years, the sluice gates are opened, and, the contest, unfettered contest begins there. People come to parliament, and they are in debt. You think they should not be looking for appointments? If their party is not in power, they fan out, they go looking for contracts. If their party is in government, they do not have ministerial or maybe deputy ministerial appointment, they'll be banging the doors of the president. Can you take me to this board? I want to belong there. And when he has recouped his monies, he's looking for the next elections. So he must also not only restock his arsenal for the next battles, but again, what he has lost, he must make good what he has lost. We must be pragmatic with ourselves. So, Justice, I think I agree by and large with what you have said, and I was saying to ourselves that the budget, we anticipate the budget maybe on 15th or maybe the next 2-3 weeks. The Constitution provides, and we're talking about strong financial control. The Constitution unfortunately provides in Article 179, Clause 2. Let me quote. The estimates of the expenditure of all public offices and public corporations, other than those set up as commercial ventures, A, shall be classified under programs or activities which are included in the bill to be known as the appropriation bill, and which shall be introduced in Parliament to provide for the issue from the consolidated fund or such other appropriate fund of the sums of money necessary to meet that expenditure and the appropriation of those sums for the purposes specified in that bill. Then it shall, in respect of the payments charged on the consolidated fund be laid in Parliament for the information of members of Parliament. What it means is that the Constitution provides for the budget to be introduced in Parliament just for our information, not for our consideration and approval. That is the 1992 Constitution. So what do we expect Parliament to do? What we are doing, the approval of the budget that we do, is by convention and practice. It's not backed by law. Unfortunately and interestingly, when you come to, I think it's the supplementary estimates, that is Article 1798, it says, where in respect of a financial year, it is found that the amount of money appropriated by the Appropriations Act for any purpose is insufficient, or that a need has arisen for expenditure for a purpose for which no sum of money has been appropriated by the Act, a supplementary estimate showing the sum of money required shall be laid before Parliament for its approval. So whereas Parliament is clothed the authority to interrogate the supplementary estimate and approve of same, for the main budget is only for the information of Parliament. That's the Constitution that we have given ourselves. And that is why I'm saying to us that indeed and in truth, we must be careful. Just today, the minority leader had filed, the minority, I should say, not the minority leader, they filed a motion of censure on the Minister for Finance. A motion of censure by our own provisions, Article 82 provides, and I was telling them that we should be a bit careful about these things, because Article 82 provides that Parliament, by a resolution supported by the votes of not less than 2/3 of all the members of Parliament, pass a vote of censure on a Minister of State. Now, Clause 4 of Article 82 says, a Minister of State, in respect of whom a vote of censure is debated under Clause 3 of this article, is entitled during the debate to be heard in his defense. That's a right. He must be heard. What if the minister elects to be heard not by himself, by his counsel? The lawyer will not be entertained in the plenary. And yet, this is what we have. Now, just oppose that with what obtains in Article 69, Clause 7, which says, the President shall be entitled during proceedings to be heard in his defense by himself or by a lawyer or other expert or person, as the case may be, of his own choice. So whereas the President is given this opportunity to be heard by his counsel, the minister no. So a minister cannot elect to be represented by his counsel. How justified is that? And Article 12 of the Constitution provides the fundamental human rights and freedoms enshrined in this chapter. Fundamental rights and freedoms, including the right to be heard by your counsel. Right? The right to be heard through a counsel, I should say, shall be respected and upheld by the executive, the legislature, and the judiciary, and all organs of government and its agencies. The legislature is required to accord this right to any person who otherwise is cited to appear before plenary. How do you do this? Is that just to the person? So, Justice, I began by saying that I have nothing useful to add to your presentation. These are mere anecdotes. Professor Chairman, thank you very much for the opportunity.
At this time, we would call on Honorable Okujetu Ablakwa to give us his remarks on the presentation by Justice M. Short.
Thank you very much, Professor Chairman. and Right Honorable Chairman. Once a Right Honorable, always pleasantly received an invitation from the Right Honorable to join the session today. And when the Speaker summons you as an MP, you have no choice but to report, and to report with dispatch. I want to also acknowledge our leader, the majority leader, the Honorable Seche Mensah-Bonsu, and proceed on the established protocol. These are very important discussions that the IEA has begun. I must commend Dr. Emil Short for the presentation, very insightful, well-researched, thought-provoking, and it's been a very courageous exposition on the topic. And I think that in this room, we are all addendum that the powers that the Constitution imposes on the President is really imperial, very monarchical, and sometimes it even borders on the extreme, and it can be even destructive if we will be blunt about it. And I am particularly excited about the proposition that some of the appointing powers should be hived off and given to independent bodies to carry out, particularly the appointment of an electoral commission or an electoral commissioner. That has been a growing source of tension. And when you are in opposition, you raise similar concerns when it is those in power who are going to make the appointment. And I recall that when we were in power and President Mahama had the opportunity to appoint an electoral commissioner because Dr. Kwejo Afarijan was retiring, there were similar calls from our friends on the MPP side that there should be a consultative process leading to that appointment. I think there was even legal action. Some of them proceeded to court. But the Constitution is clear. Interestingly, one would have thought that when they had the opportunity, when Commissioner Charlotte Osei was removed, they would have gone back to the presentations they made and all the articles they wrote and all the agitations and all of that, and will have set the tone, you know, set a nice example by opening it up and letting us have a consultative process towards the appointment of the current commissioner. But that didn't happen. So the only solution really, we all know what is right. We have espoused some of these views when the shoe has been on the other foot. So the proposition is one that I believe that should be acceptable to all of us, except that we may have to probe further into how we go about that. The bodies that Dr. Emil Short lists, very, very interesting bodies. But even within those bodies, those associations, those organizations, you don't really have a certain monolithic structure or construction. If you say the Christian Council now, there's so many of them, so many facets, so many groups, even within them, you know, some of them consider themselves holier than, you know, than others. So if you say civil society, that relates to governance. What really will be the criteria? These days, there are all manner of groups mushrooming, single-purpose vehicles, and all of that. So, where I will ask for some further discussion will relate to the vehicle to use and how we do the selection. And we should also not proceed on the basis that just because you mention a group, Christian Council, Muslim Council, or a CSO, they are necessarily neutral or independent. It's not a given. There are some that are credible, that care about their image, care about their reputation, cannot be, pushed, cannot be influenced. But how many are they? Not all of them. So we must also have these considerations in mind. And then, do we totally oust the political parties? We may also have to discuss that. Can they be involved so that they can see how transparent the processes are, even if they will not probably be having a vote? But can they be part of the processes, particularly political parties that meet the test, that have representation in parliament? I would think that if you involved the political parties as key stakeholders in the elections, it may not, be a bad idea. So I noticed in the list that political parties were exempted. Maybe, as we have this discussion, I'm sure Dr. Short will tell us why he omitted the political parties. But probably we may want to include, the credible political parties. There are. Yes, I'm particular about that. Credible political parties, not one man or one woman parties. Yes. So with representation in Parliament, I think will be great. Then I also reflect on where we are now as a country. I think that the 1992 Constitution did well to give us political stability. Now our people are yearning for development. They want to enjoy the democratic dividend. So it's not just a matter of stability, every 4 years elections. When we have voted, what comes out of it? How does that improve livelihoods? How does it improve quality of life? So there ought to be some shift towards transformation, a development-oriented constitutional architecture. And in that spirit, I see so many provisions in the 1992 Constitution which are inimical towards that agenda, that mindset, which our people are really yearning. We should be discussing serious caps at this point. Do we need 275 members of parliament? I don't think so. And many Ghanaians do not think so. And at some point, you see, the way it is now, where the Electoral Commission conspires with, the local government minister or the government of the day, and I use the conspire advisedly, that's the whole arrangement. We all know it's led to gerrymandering. We started with about 100. See where we are in this short space of time, 275. There's some talk in the air that we may soon be, approaching the 300 mark. Is that going to continue? And you go into some communities and everybody is asking for a new constituency, new district, and all of that. It's a drain. It's a drain on scarce resources that could be spared for development. We are spending it on big governments and expanding the political elite. So it will be good to see some caps placed. And when I refer to caps, it's not only with the legislature, but also the number of ministers. You see, when you really look at our constitution, sometimes it starts very well, you take Article 76, for example, which says that a president should have maximum of 19 cabinet ministers. So minimum 10, maximum 19. Then by the time you get to Article 78, this is destroyed. It's mad. When Article 78 says that the president can appoint such other ministers as he deems fit in the efficient running of the state, it negates. You see that Article 76 was really having quite a lean, efficient scope. Then the floodgate is open by the time you get to Article 78. And I agree with the Honorable Chairman Sabonsu, who made the headlines some months ago that this country really can do with the 19 here, the maximum cap for cabinet ministers. We can do with that. So I think that a certain bold, in this constitution, we give the president too much discretion. So let's have a cap. Perhaps we thought that, okay, presidents would not really enjoy that discretion. They will not take too many liberties. But that is not what has happened. You see that successive presidents, and I'm not being specific, the spirit of this discussion is not to, not to point fingers at any specific or individual, So it is the principle. And you see that it's been going up over the years. We need to place a cap on that. Presidential staffers is another one, and that is derived from the Presidential Office Act. So we are a country yearning for development. There are scarce resources. The tax net has not been widened as it should, and yet we keep having a very expansive governance, arrangement, and really, I thought that that's something we should be looking at. Do we need regional ministers? I don't think so. That's one area we can hive off from the Constitution. We have MMDCs who can operate, really. There's a local government minister if it's about coordination. So I think that we should really take this opportunity and be very bold so that we can spare resources. The elephant in the room, Article 71, what do we do with it? When Dr. Short, Dr. Emil Short is synonymous with Shraj, so forgive me. When Dr. Short was referring to bodies we can set up and give them specific mandates, as we hive off some of those appointing roles from the president, I thought that we could also pay regard to the whole Article 71 arrangement, so that we remove the president and remove the members of parliament. As it is now, the legislature approves that of the executive approves the conditions of service, the end of service benefit of the legislature. It has become, entrenched in infamy. People say it's just a scratch your back and you scratch my back, I scratch your back, and all of that. It has not helped, and I thought that boldly we could remove, because we should not be seen approving our own conditions of service. The United Kingdom has the House of Commons. They've just carried out some reforms, in recent years, and I think that we can study what they have done. They've removed the whips, removed MPs. They don't take the decision, so they have an independent body, an independent emoluments commission that takes the decision based on, the state of the economy, based on the conditions of service for workers generally across the public sector. If we did something like that, I think that it will remove the tensions that we are seeing with organized labor, coming after the political elites And then that notion that people come into public office, just to enrich themselves and because of what they will benefit at the end of every 4 years. And as we discussed Article 71, I also take the view that if you're a member of parliament returning or a minister of state, your party has won and you will be retained, you should not receive an ESP, you should not receive an ex gratia. It should only be made available for those who are leaving, who are really retiring. There are things that we can do that will restore confidence and will change this narrative that people think that many are coming to public office just for themselves. So as I conclude, I also want to share a thought on the current developments in Parliament, the vote of censure, the finance minister's fate. Interestingly, and again, this constitution that fears any precedent. If you look at Article 82(5) of the Constitution, it says that where a vote of censure is passed against a minister under this article, the president may, it's not shall, may, unless the minister resigns his office, revoke his appointment as a minister. So we have begun discussions. I mean, if we succeed with the vote in Parliament, this may, doesn't it, tell you that the president can just rubbish what the overwhelming majority of the House decides? Why was this provision couched that way? So even where we want to compel the president to act in this constitution, we are so timorous, and it's amazing, and you wonder what we fear. So, and what are the implications if there's a vote of censure on the minister, 2/3 vote or more than 2/3, and the president refuses to comply with the decision of the House? Can that minister attend upon the House? Can government business regarding that sector be conducted? And what does it portend? So I think that provisions like that, it's clear when you go through several articles in this constitution that we need an overhaul. And yes, I am also not for the gradualist or the tinkering or piecemeal camp. I don't subscribe to that camp. I don't belong to that school of thought. We should seize the opportunity and have an overhaul. Fortunately, the Professor Mills era afforded us some work, over 700 pages of Constitution Review Commission work. We spend millions of dollars on that exercise. I don't think it should go waste. I don't think we should cause financial loss to the state. Let's pick it up, let's dust it, let's add it to what is going on now, and then finalize the process. I think that there's been a lot of talk. We all know that this is popular. The Ghanaian people want a development-oriented constitution, a constitution that will take us to the next phase of national reconstruction. We cannot continue to wait. So these are my own thoughts. Perhaps I should finally deal with the matter of corruption. Professor OQUAYE, I know that Professor OQUAYE has been passionate about fighting corruption. Should we keep the current arrangements where the president appoints the Attorney General? We wanted to address that matter by creating the Office of the Special Prosecutor. But because the Office of the Special Prosecutor is also really appointed by the President, what did we achieve? So perhaps in considering the positions that we should have other bodies appoint, removed from the president. I will appeal that we can consider the Attorney General. And when we do that, we may not even need the office of the president, the office of a special prosecutor. I think they should be merged. I think that we have too big a size of government, too many political appointees, and too many institutions that are, engaging a lot of duplication. So if we can take a second look at that, I think that it will be a bold way at addressing, the corruption canker, so that fighting corruption does not become fighting my predecessor's corruption, fighting, the corruption of the past. But when it's happening now, I see no evil, I hear no evil, and I cannot act on any evil. That approach really does not help. And I would just appeal that perhaps that's one of the things that we can look at, where we hive off this Attorney General's role. Let us have a prosecutor who is not appointed by the president, who has a secure tenure, and then can fight corruption across regimes and at all times. Right at the moment when corruption takes place, you can be assured that that corruption allegation can be looked into, there can be prosecution, and then people can be dealt with. So thank you very much, Doc. God bless you. Very good job. Thank you.
So now the floor is open for discussion, and we would have brief discussions, after which Dr. Nana SKB Asante will give some few remarks. So please, I'm going to take some questions from you. Please keep it minimal, and so that we can have multiple questions and dynamic discussions. Thank you.
Human Rights Administrative Justice. Thank you so much, Justice Dr. Emil Shaw. Very invaluable discussions, particularly against the backdrop of the broader political and social processes, the geopolitical transformations now. There couldn't have been a better time, and thank you. But I have just two brief questions. It goes to IEA. There have been, I'm sure there are useful recommendations stemming from the presentations. Where are you going from here? Is it just going to stay in the shelves? What's the trajectory for effective follow-up? That's very important. Are the political parties going to be part of the process? How participatory is the process? And then secondly, I also wondered, we didn't start on time, and I'm sure when Justice Short came in and there were few people and chairs were being rearranged, I'm just wondering, could you probably consider a parallel virtual session, maybe subsequently, or is it supposed to be a closed session? Maybe that's something you could consider. Thank you.
Thank you. One more question then.
I would like to extend gratitude to the IEA for inviting the Progressive People's Party to this program. My name is Nana Ofori-Owusu, Chairman of the Progressive People's Party. If it was Dr. Shaw's presentation, because I'm not in Parliament, I would not be here. So I would like to thank the good professor for inviting me. It is the good professor who said that the powers of the executive is so much so that he controls the seating arrangement in Parliament. The king's men sit in front and everybody else sits in the back. And he was talking about the overreaching powers of the executive into the legislature. We have majority leader, a very powerful position in the legislature, who's also a minister for parliamentary affairs and participates in cabinet meetings. So you go to Parliament, you decide on a policy, then you run to the legislature to vote on the policy that you have decided on. We need to look at Article 78. Our last press release from the Progressive People's Party dealt with this amendment matter and the conflicts that it gives us as a people. And we are leaving things to the benevolence of leaders. when we need to focus on the institutional reforms for us to be able to move forward. So if you look at the platform of the Progressive People's Party, it is all about reforms of our constitution. Because until we get it right structurally, and we leave it to the benevolence of men and women, we have a problem. Because the present impasse, we have been hearing whispers from the majority about their dissatisfaction with the present Minister for Finance. We've been hearing this for a very long time. And it is recently that they have been able to try and take a step in trying to move for censorship and arrest. And then we hear backstepping in these decisions that they took after a series of meetings somewhere in the hills. So so you see that the legislature, as the good professor will say, has become a poodle of the executive. And until we deal with these structural fundamental issues, we leave it to the, we talked about one-party states, where Nkrumah had a one-party state. Right now, we have the same one-party state in a democratically elected governance, whereby the elected party controls all the resources of the state and does not share. And it leads to this serious conflict between the political parties, and the winner takes all. And that is why we were so sad when we have been advocates of electing of MMDCs. We got to the crossroad and we could not jump over. We've gone back. And so until we reach the structural changes within the shortfalls in the 1992 Constitution, we will always be talking about some of these things. So I'm also interested that with the talk shops that we have been having, the discussions that we have been having, what do we do next in trying to make sure that we push for the necessary changes in this, our 1992 Constitution? Thank you. Thank you.
Secretary of the People's National Convention, whilst looking at the Right Honorable Dr. Short, I saw that the committees, it was political parties that have representation in Parliament. And I was like, are we now violating the Constitution of Ghana that is encouraging us to have multi-party democracy? Anytime you have these two political parties, when they say two political parties, parties that have representation in Parliament, we all know who they are, NPP and NDC. They go for meetings and then they are fighting for their political colors. At the end of the day, it is about their entrenched party positions and not national interest. So for us to have something important of this nature and we'll pick the two of them to go there, it will end up turning into a third world war. I will suggest that 5 political parties, instead of 2 political parties, it should be 5 political parties. I also heard what Honorable said. Honorable Okujato, he said they will do what they can do and then they will leave everything because they will not, at the end of the day, they don't have power to remove the finance minister. I think that in US, the Congress impeached Donald Trump and Senate disimpeached him. That's how it is. It has always been like that.
Thank you.
Thank you. My name is Felix Manti, the Communications Director for the Progressive People's Party. I see my lecturer here, so I'm humbled. Thank you very much. This discussion didn't start today. It has started a long time ago. My question is simple. What has been halting the progress? Is it that it doesn't suit the interests of governments in power? It doesn't serve their political interests? That's why at a point in time it vanishes into thin air for the review or amendment of the 1982 Constitution. What make progress. And coming to the appointments and the recommendations Doc gave, what do we do with the Public Services Commission, especially for the appointment of state or governance institutions that are permanent? Let's take, for instance, when the Vice Chancellor's position is vacant, there is a process that they go through. It's advertised, and then people who feel they are competent, they just get in, and then we get them on board. Do we need to invent the wheel again? Whilst we have the Public Services Commission, who we can follow to do a good job, or strengthen them to do a good job for all of us. Thank you.
Thank you. Right Honorable Speaker, honorable members of Parliament, distinguished ladies and gentlemen, I didn't really want to come, partly for the reasons that have just been stated by the last 2 or 3 speakers. We have been debating this for years. I was a member, a chairman of the Committee of Experts that formulated proposals for the Constitution. Our proposals were then submitted to the Consultative Assembly. And right from the word go, our proposals were subjected to severe critique. Consultative Assembly did not accept a significant number of our proposals. In fact, they wouldn't even give us the benefit of even sitting in the hearing, in the sessions. And so sometimes when I'm called the father of the Constitution, I want to disclaim certain portions of the Constitution because there were critical recommendations of the committee were rejected. Example, the nature of the Council of State. The Right Honorable Speaker mentioned, ex-presidents, but not only ex-presidents, as chief justices who wanted to have a very viable Council of State, membership of 40 or so, appointments made by various organizations, including Parliament, the President's role limited to a very, very small appointing powers, so that you have a forum where a partisan victory at the elections would not necessarily determine the debate. They rejected that. Talking of the division of executive powers, we proposed executive president from prime minister, so that there will be a diffusion of the executive authority, and that there will be also a division of labor, with the president having time to travel abroad and represent people, and the prime minister actually coordinating the economy, the management of the economy, and so forth. And they said, oh, you can't have 2 lions in the same hole, among other things. And that was rejected. We wanted a strong executive, not only from supporters of PNDC, but from supporters of people like Bachelor Folsom, Professor Folsom, who was certainly not on their side. They wanted a strong executive to hold the country together and all the rest. We proposed the election of what is now called the chief executives of district assemblies, but not by the entire electorate, by at least members of the assembly. That was rejected. We raised the question of proportional representation in a very strong form. Even went to Germany to study that system of proportional representation, which combines various elements. That was rejected. It's too complicated. We wanted a local government which would really decentralize the predominant feeling is that we don't want local government to be too autonomous. We want them to be controlled by the central government. So this was the mood of the Consultative Assembly, which came out with a final draft. And I must point out that because they rejected a significant number of our proposals, they fell back on previous constitutions. So if you look at some of the excessive presidential powers that we are complaining about, they were all in the 79 constitution, most of them. That's, you know, the appointment of people to serve in the public service shall be vested in the president in accordance with the constitution. That's right. That's 79 constitution. The much criticized Article 71 wasn't really discussed. It was lifted from Article 55 of the 1979 Constitution. So that was the background. And then we are talking about constitutional limitations and so forth. But people have forgotten how politicians act. I can give you 2 or 3 clear examples where, in addition to the provisions of the Constitution, more powers have been added to the executive. Consider, ladies and gentlemen, the Presidential Transition Act. That was the act which for the first time enunciated the rule that upon the swearing in of a new president, all public and statutory corporation boards will be dissolved, the new ones appointed. That was the first try. Previously, they were trying to implement that by practice. So in 2012, for example, a letter went round from the Chief of Staff, various corporations, including the Bank of Ghana, stepped down because there's a new government. And people like Sam Okujeto, challenged this. So then they came with a Presidential Transition Act, which was quite clear that chief executives as well as members, directors of all these will be removed upon the swearing of a new president. It was only the Supreme Court subsequently that qualified it by saying that chief executives would remain in statutory because they were public officers, that the removal goes on. That was not by virtue of the Constitution, it was by virtue of additional powers under the Presidential Act. Another thing, until the Right Honorable reversed the situation, a Speaker of Parliament had interpreted Article 108 of the Constitution to mean that every measure which involved the minutest expenditure would be subject to presidential approval before the bill was introduced. The Right Honourable Speaker said, this is not warranted by the interpretation of the Constitution. That's how it started this private members' bill. Before then, members of Parliament just accepted the position that they could not prepare and submit bills. So we have to look at the appointment of members of Parliament to boards. That was not warranted in the Constitution. So my other point that I want to raise is this. Do you really think that all the restraints that are necessary should be constitutionally stipulated? And people were saying that, you know, there should be a limitation on the number of ministers. It's really a matter of, you know, management, a matter of common sense. You can't have excessive. Do you want the Constitution to say you can't have this? In order to do this, you want the Constitution to stipulate the number of Supreme Court judges that you have? Do you want the Constitution to say that you must cooperate as rival parties in order to advance the national team? The only thing I have against the proposals of the, you know, winner takes all committee of IEA is that they did not actually go to the extent of saying that politicians or political parties must share power. Yes, why is sharing power not contemplated? If you share power, then there will be no need for this panic at every election, because there will be something for a particular party. There will be some participation in the appointment of all the things you are worried about, you know, electoral commission, charges and so forth. All these can be worked out. You know, if you look at the Constitution, it does not say precisely that on the election of a new president and so forth, all ministers should come from one party, the victorious party. There is a certain tradition of winner-take-all which has seeped into our culture by virtue of what we have learned, erroneously in my view, from the US and the UK. In other European constitutions, there's an approach. So I don't want to take too much of your time, ladies and gentlemen, but I want to know whether you think that every area of human behavior should be regulated by constitution. Yes. And if not, should there be some ethos, some constitutional ethos, some feeling that certain things should be done this way without a constitutional restraint? Look at Britain. You know, they didn't have much of a constitution. They became a world empire. Not by virtue of the perfect nature of their constitution. Hardly any written constitution, just a few principles. Korea, China, and others have become world powers, not by virtue of any constitutional perfection. Thank you very much.
We get responses of the questions from the high table.
Thank you very much. Distinguished ladies and gentlemen, we've had a very good evening. And I have to make a few remarks concluding a few issues that my colleagues here have brought out for me to submit. I'd like to acknowledge the presence of Nana Dr. Mahamidichi Jando, the immediate past head of the Political Science Department in Lagos. In fact, she is at the moment doing sabbatical here at the IEA, and we have a number of visiting scholars in-house, including my classmate who sits right before me here, and also our MC for the occasion. We will want to make a few contributions by way of explaining a few things. And the question, who are these, was asked, where are we going from here? Definitely, this being a think tank, in fact, the first think tank in Ghana, and of such excellence and concern regarding national affairs, we want to interrogate this matter of the Constitution. First of all, by gathering learned viewpoints. In fact, among other things, we started it all with Nana Doctor, for good reason. For good reason, next we had our leaders of parliament. And we are proceeding with them as partners, they themselves or their representatives, because they are very relevant to constitutional amendment also, as we can see. And we are particularly also glad when concerned citizens like you here come and participate. We take it as a search. This is a search party approach, and trying to gather knowledge, data, and information. And we are particularly glad to have as we have experienced tonight, the viewpoints of Dr. Emil Short here this evening. And we're going to have such views regularly, every Tuesday, and we'll invite the media to take this seriously as we proceed. We are moving to meet President Kufuor, who is the only living former president in this country. Also, only living former president who has served 8 years. I'm sorry. So definitely he has got considerable experience. He will not be able to come here, but the mountain will move to Muhammad. Of course, other presidents will be approached to share their viewpoints. Very, very important. When all these have been done, then we shall have a few experts to collate the recommendations and then take them to civil society and to government and to all relevant persons asking for a constitutional commission or whatever we call it. We want to note that when we come to talk about the Transition Act, which today has brought a lot of sanity into our changing from one regime to the other, it is the work of the IEA. So the way we went about this in this house and drafted that act and got relevant persons, including the late Dr. V.C. R.A.C. Cloud Justice, to assist, will be done again, and then we'll have something presented to the public. But we think public civil society must take a leading role in this particular process. And in doing so, we are building a partnership, academics, civil society, parliament as an institution, concerned, identifiable Ghanaians, men and women like Justice Brobe, the former head of the Department of Political Science. I've just introduced Justice, retired former Chief Justice, Madam Akufu, and others will be coming to share views on certain specific areas. And in that connection, we would rather want to find ways and means of. I'm very sorry that my good lady who was invited from her institution, that is NCC, not so, it's not here, but it will convey to her. We want all these institutions to participate seriously so that we shall appreciate the full dynamics of the task that the IEA governors have set upon themselves. The winner takes all matter has been so well looked at by our speaker this evening, and we trust that those who are yearning for development will continue to look at this, what we describe as an architecture for an agenda regarding this, and the approach of the budget, etc., that needs to be a matter of professional consent. I'm particularly noteful of this meritocracy issue that was brought in this evening. In terms of the example of Singapore, are we really bringing in a system that will allow, in fact, will mandate meritocracy? And this, what he just said, is what we also describe as a bipartisan eligibility test approach. Eligibility. In other words, we're going to have a number of institutional representation, and they will make a list, a short list. Mind you, one more time, the IEA commissioned this search with a number of persons, including our speaker for this evening, and also certain other eminent persons. You have a right to choose, Mr. President, but the experts in health will help you to choose the medical council boss by way of limiting this to 5 or recommending 5 for you. It's an idea. And I want to also add that the list that Justice Short gave is not an exclusive one. It's an inclusive one. So, of course, others can bring other suggestions as, oh, put this one too in. It will enrich the process, and so forth. It's not meant to be exclusive. But it's a very, very important approach to limit the hands of the person who is going to make the ultimate choice, or to guide that person as to the experts. We are the medical people, and we know the real experts in the public health system. So we are recommending these 5. Mr. President, you can choose anyone from these 5. This is a concept that will encourage the meritocracy approach towards good governance. And these are the issues which, when fully guarded, will help us in this regard. From what I've heard from my good friends from Parliament, the appointment of majority of ministers from Parliament is something that is worth looking at again. And if we want to go the parliamentary system, then we must also look at a situation whereby all ministers are chosen from Parliament, just as it is in the USA. And this is either in the UK or like the USA. Well, if it is a presidential system we are doing. Then, as for the committee of the committees that will be making representation for appointment, there are other groups that the majority leader has, including the UTA, Ghana, CHAS, Ghana Medical Association, and others. And so it goes to establish further the point that it is not inclusive, and the Honorable Justice did not intend it to be inclusive. It was just actually sharing with us a very, very interesting idea that came from the IEA Committee of Experts report. So when we've got all these, then we can sit and make appropriate recommendations. We invite you to continue participating so that whatever is the end result will be well examined and well founded. We thank you very much for coming, and we look forward to seeing you here next week. Thank you.